I have been expecting the Commissioner of the Department of Education, Commissioner Charlene Russell Tucker, and we're checking on whether she's having some problem getting on or not.
Okay.
I invited two other people, the plaintiff's representative and our plaintiff's expert, and I don't see them on, but they might have had the same problem that Elizabeth did. Can you check, Kara, if they're having problems getting on?
Sure, we'll do.
Yeah, Jill, I'm checking. I'm having a key check with Anne Marie to make sure the commissioner's not having trouble.
Thank you, Robin.
If they don't have any kind of a speaking role, they could probably just watch the live stream if that expedites things. You're muted, Joe.
They may or may not need to speak.
Good afternoon, everyone.
The Superior Court of the Hartford Judicial District is open and in session. Honorable Marshall K. Berger presiding in the matter of Sheff versus O'Neill, docket number HHD CV 17-504-5066S. Good afternoon, Your Honor.
Good afternoon. I'm informed that we're waiting for someone. Is that correct?
Your Honor, we are waiting for the Commissioner of Education, we just got a message that the Commissioner's not immediately available and would like us to go ahead without her. And I think Attorney Stone was also waiting for a person or two.
We were waiting for a plaintiff's representative and our plaintiff's expert, but I don't want to hold up the court, Your Honor.
Okay, well, we'll give a moment and see if they show up.
Yes.
I got a meeting that the Commissioner was in a meeting with the Governor, and so she might be a while. So I won't ask the court to wait for her.
Yes, you can proceed, Your Honor.
All right. Mr. Sheff, good afternoon. You're on mute, but I think you're saying good afternoon.
I am. Good afternoon. Happy New Year. Great to see you.
Nice to see you. All right. We have before us a motion for a permanent injunction. Who would like to proceed?
I'm planning to make the opening remarks, Your Honor.
Please.
April 27th, 1989, the day we filed Sheff versus O'Neill in Superior Court. Now, a defining moment to return to the same court some 33 years later to seek approval for what the plaintiffs hope will finally eliminate all of the inequities they sought to address on that fateful day. It's historic, Your Honor, in another way. To put the years in perspective, Milo was 10 years old when we filed the case, and today is Milo's birthday. And Milo is 43 years old today. During these 3 decades, thousands of children have benefited from the opportunity to attend quality integrated schools, but unfortunately, thousands have been put on wait lists or have been denied that opportunity in other ways. You've seen us numerous times, as you know, Your Honor, 6 stipulations later. And I know you always joke with me that I start my remarks with the same each passing day quote from Justice Peters, but I'm not going to use that quote today. Instead, I'd like to remind all of us of the quote from the Langston Hughes poem that we recited on the very first day of the trial in the first hour of the court hearings on December 19th, 1992. What is a dream deferred? Does it dry up like a raisin in the sun? I'm hopeful today that the dream that the plaintiff shared then is on its way to being fully realized. And before I highlight for the court the details of the CCP, which is the Connecticut School Choice Plan, and the permanent injunction, which is the second document before your honor, I'd like to take a few minutes to recognize the efforts of those who made this day come to fruition. In addition to my legal team who's on the screen today, I'd like to recognize Assistant Deputy Attorney General Joe Rubin and Corporation Counsel Howard Rifkin for their efforts and their teams. And I would like to also recognize Robin Cecere from the State Department of Education and Doug Delana from the governor, who is from the governor's office. And I'd like to mention two members of our team, Alex Knopp, who was the plaintiff's representative for a number of years, as well as Erica Frankenberg, who's been our plaintiff's expert for the last 5 or 6 years. As you can imagine, these were laborious negotiations over the last 5 or 6 months, and I think we all emerged from them with tremendous respect for each other's tenacity, as well as an unwavering commitment to quality integrated opportunities for the children in Hartford. And of course, I want to recognize the plaintiffs, Your Honor, who have been with this case from the beginning: Tom Conley and Carol Vinnick, Jean Leach, Leo Harrington, and of course, most importantly, our stalwart leader, Elizabeth Sheff, who's really, Elizabeth, you've been the heartbeat of this case forever. And you've been an inspiration to me. You've been by my side year after year and hearing after hearing, never losing hope despite the fits and starts over so many years. And I am very, very grateful for that. And I think everybody on this call and hopefully everybody listening really respects you tremendously for what you've done. In the negotiations, Judge, we set out to accomplish 4 things, 4 goals. First was to achieve racial and economic diversity in a quality integrated setting. The second was to measure and meet 100% of demand. That means that any Hartford child that wants an integrated setting would be able to get that opportunity. The third was to guarantee accountability so that everything that we agreed to today, there would be some accountability. And the last is to ensure sustainability. So I'd like to go over the first 2, briefly turn it over to my co-counsel, Karen McClellan from the NAACP Legal Defense Fund, and then address and finish my remarks. So as to the first one, the issue of achieving racial and economic diversity, Your Honor, what we were able to do was to preserve your court ruling of August 2017, which is on page 5 of the CCP, as well as preserve the economic diversity goals in the 2020 stipulation. There are a lot of paragraphs in the executive summary. I know it's unusual to have an executive summary as part of a court document and as part of court proceedings. But I think that one of the most important statements that we made in the CCP is on page 8, and it's part of the executive summary. And I say we because collectively it's all of us on this screen, it's the governor, it's all of the parties, City of Hartford, the plaintiffs, the defendants. And we state on page 8 of the CCP, quote, "The value of integrated education extends beyond a state obligation arising from a Connecticut Supreme Court decision. It offers Connecticut students the opportunity to develop meaningful relationships with people with different racial and ethnic backgrounds, reduces racial bias, and prepares students for the global world." That's why we put that sentence in that. That's why we also on page 8 say that this is a compelling state interest. And that is also why on page 2 of the CCP, it's called a fundamental piece of the state's educational landscape. And I think that those phrases really guide us. They guided us in the negotiations, and hopefully they'll guide us in the implementation. The second goal that we set out to achieve was to measure and meet demand. And I know everybody's going to ask, and say, well, I thought you did that in the 2020 stipulation, and I thought you did that in the last 6 stipulations. And so what's so different about this stipulation that makes it so momentous? And I'd say that, having been with this case for 33 years, what makes this particular decision, this particular body of legal work different is we've been asking the state for a plan. We wanted a plan. How are you going to meet demand? Are you going to commit to demand? And so for the first time, this CCP and permanent injunction does both of that. It meets demand. It has a roadmap to meet demand, and it has, most importantly, the funding that backs it up. So these are the components of this CCP and permanent injunction that I think are different. There, in this agreement, there is a call for 2,737 new seats for Hartford children. The way that we are going to get to that number is in 3 different ways. One way is to expand the existing magnet schools to capacity. The second way is to increase the number of open choice seats by adding incentives. And the third way, and this is the other piece of all of this that's new, everybody says, oh, what's new? There are new options here. There is a technical high school. There is a new dual language program. There is a new early literacy program. There is a reformulation of several magnet schools with new themes and partnerships, including Amazon and Microsoft. And then there are initiatives to improve quality, because we've always been about, and Elizabeth always reminds us, it's not just about integrated schools, it's about quality integrated schools. And so what we have put in this agreement are initiatives to improve quality, which include magnet coaches and most particularly after-school athletic and enrichment programs, which magnets never really had before. So I think that what's important is that not only will there be over this next 7 to 8 year period a increase of the number of seats, but there is a commitment to meet demand. No matter what that demand is, there is a commitment to meet demand. So if demand exceeds capacity on page 19 of the CCP, then the state will meet that capacity. So I'm going to turn it over to Karen McClellan now to talk about the accountability goal, which was also important to us.
Thank you, Martha. As co-counsel has just outlined, the success of the goals the parties have agreed to depend on deep commitment, as we all know, backed by funding and strategic long-term planning. So in the permanent injunction, we've included provisions to ensure accountability, and I'm going to highlight a few of those provisions. First, Your Honor will see that the State Department of Education will establish a working group to really deeply engage in this cohesive long-term planning, including forecasting future enrollment to plan for new seats, assessing and recommending retheming and reformulation based on what we know are popular themes, and increase access to extracurricular options, as co-counsel just mentioned. There's also provision on page 28 that outlines an audit process to evaluate each school and program, and to restructure schools to increase diversity in a strategic way, and to provide necessary funding to support reformulation strategies. So schools will have the opportunity to work with magnet coaches on reformulation. And importantly, the agreement provides for $12.6 million to operators over 3 years to reformulate schools as necessary. Next, there will be annual tracking and publication of data on student achievement, attendance, graduation, retention, college attendance, and discipline. As mentioned, and as we are reminded often by Elizabeth, students and their ability to perform depends not just on what school they attend, but racial equity within school buildings. And so we want to make sure that this information is tracked and made public to ensure students of all backgrounds have access to an integrated school that's providing a quality, equitable experience for students. There will also be annual reporting to the plaintiff's representative as part of the RUSCO office regarding enrollment, socioeconomic and racial diversity data, attrition, extracurricular offerings, and the application process. And then importantly, and this goes back to school quality, there will be reporting on each school's efforts to ensure culturally relevant curriculum to ensure equity in terms of students' experience and access to materials. There will also be targeted marketing and outreach to underrepresented populations. And finally, critically, a commitment to hire staff that reflects the diversity of the region as a whole. I'll turn it back to Martha.
Thank you.
So the last goal, Your Honor, that we had relates to the sustainability of all of what we have done. And we have put in both the permanent injunction and in the CCP 2 fail-safes. The first is, as I previously mentioned, that there is a commitment to meet demand, and that if that demand exceeds capacity, the state has committed to meet that demand. That's found on page 5B and C of the CCP and on page 19 of the CCP. It's also found on pages 2 through 4 of the permanent injunction. And there will be a reassessment every 3 years because, as we know, it's hard to plan like what is going to be needed 9, 8, 9, 10 years from now. The second fail-safe that is really important that plaintiffs really stressed in the permanent injunction is the ability to go back to court if there is non-compliance. You know, we're hopeful today that we will not have to come back to court, but we need to assure that there is some mechanism for the plaintiffs to hold the state accountable to both the meeting demand and all of what's in the CCP. So if there are breaches of material facts, the plaintiffs do have the opportunity to come back to court. So while supervisory jurisdiction may end, and this is a 10-year permanent injunction, the plaintiffs always within that period of time have the ability to come back, even if it's 9 months, 9 years and 11 and a half months, and there's non-compliance, then the permanent injunction will extend beyond the 10 years until the court otherwise rules. So those are the fail-safes that are in here, among other provisions for sustainability. I'd like to conclude, Your Honor, by reflecting really that I think we've accomplished a lot, but there are some challenges ahead that I would like to mention. We're not going to be successful in these efforts, all of us, unless first the suburban districts will re-examine their willingness to open up their schools under the Open Choice program to educate more Hartford children. Last year alone, there were 896 Hartford kids that wanted to go to school in the suburban districts in non-entry grades, and they never got that opportunity. Secondly, the legislature has to approve this agreement and take the financial sustainability issues seriously. We can create all of these good magnets and all of these options for kids, but over time they need to be fiscally sustainable, or this whole effort will not succeed. And lastly, there has to be continued leadership at the top. You know, we ask our leaders, what do you stand for? And today, Attorney General Tong and Governor Lamont and State Department of Ed Commissioner Russell Tucker, they stand with the Hartford children, some of whom are only babies today, ensuring that they will have a quality integrated education and the Supreme Court's decision will be complied with. And Attorney General Tong is on the call today, and for that, we thank you for that. We thank you for that. And I'd like to end, Your Honor, by thanking you, because what do we stand for? You have stood on behalf of the principles of equal educational opportunity, and you have shepherded this case for a very long time. And we couldn't be where we are today without your guidance and your wisdom. And for that, we are all grateful.
Thank you. Mr. Rubin?
Thank you, Your Honor. Your Honor, my friend, Attorney Stone, has eloquently and accurately described what brings us to today. I'm just going to summarize a couple of points very briefly and then turn it over to the Attorney General for some brief comments. More than 30 years ago, Elizabeth and her counsel started this important case. And 25 years ago, the Supreme Court told us that students in Hartford had the right to quality education in a more diverse setting. Over the years since then, we are proud of the tremendous progress we've made. But I have to say that in the last 3 years, I've been able to work under the direction of Attorney General Tong and the governor, and the direction they gave me is we want to resolve this case together, and we want to together vindicate the rights that our Supreme Court established in Sheff. And I believe that today we present to you an agreement that will do that. It will not only result in the end of the litigation, but it will result in the vindication of those children's rights with a promise of a quality, diverse educational setting for all Hartford students and families who so choose. We are proud that we have been able to work together to achieve this result. We hope that the General Assembly will agree and approve this agreement, and that we will then be able to bring it back to you for final approval. And with that, I'd like to ask Attorney General Tong to speak.
Thank you, Joe. Your Honor, if I may.
Certainly, sir.
Thank you. Let me first say happy birthday to Milo, and congratulations on 43. The numbers seem to get bigger. I'm a little grayer too. And let me just say, Your Honor, that when we last appeared before you in person, hopefully at some point we'll get together in person at some point again. We announced a two-part settlement. And though we were confident on that day that we would get here, that was by no means certain or a foregone conclusion. And I want to start at the outset by saying we wouldn't be here but for the perseverance and doggedness and commitment of everyone involved, but in particular, Martha Stone and Joe Rubin, and their ability to work together and to find common ground and to broker this compromise. I also, of course, want to thank Elizabeth Horton Sheff and Milo again for your perseverance and your commitment to this over these 33 years, I guess, if that math works based on how old Milo is. Also, your partners at the NAACP Legal Defense and Education Fund and the City of Hartford. Thank you, Corporation Counsel Howard Rifkin, for being here and for your commitment. So I also, as much as I want to thank the plaintiffs for your perseverance and commitment and your fight for all children, I also want to thank everyone in this state who's participated in this effort over these 3 decades plus, and acknowledge that the state and the people of Hartford have already made significant investments in pursuing all the goals that Martha Stone outlined and that the Supreme Court commanded us to meet. And that this part 2, this settlement, gives us a roadmap and a commitment to which the state is fully committed going forward to make even more historic investments in the future of the children of Hartford and the surrounding region. And that's why we're here, not just because this settlement vindicates the constitutional rights of students in Hartford and the region to a quality and diverse education, but because we make this historic investment. And I think when we talk about education funding, we often throw words around like fairness, access, equity, and sometimes we use those words so much that they may at times lose meaning, or it's not always clear what we mean by fairness, access, and equity and diversity. And I think today we see that this is what we mean. This commitment is what we mean. And on behalf of the state, we take that obligation and responsibility very seriously. And if I may add, we take our obligation and responsibility not just to pursue fairness, access, and equity, but in your honors court to pursue justice. So let me thank your honor for your stewardship. And if I may, with your indulgence, I'd also like to thank a number of folks who, without whom we would not be here today. I want to thank the governor and his former senior associate counsel, Doug DeLana, many folks at the State Department of Education, including Commissioner Charlene Russell Tucker, former Commissioner Diana Wenzel, SDE counsels Peter Haberland and Jessica Myrtle, counsel Mike McKeon, in-house attorney Matthew Venhorst, and especially the head of the Regional School Choice Office, Attorney Robin Cecere. I want to thank the Office of Policy and Management and the Secretary Melissa McCaw and her predecessors, her former counsel Claire Coleman, Assistant Secretary Jeff Beckham, and their staff, including Holly Williams and Peter Hopko. And of course, from our own team, you've seen many people come and go. Some have retired. We would not be here but for Henry Salton, as you know, Your Honor, and Ralph Urban. But today we're joined by Associate Attorney General Eric Lohr, Assistant Attorney General Darren Cunningham, who has done a tremendous job in this case, and speaking for the Office of the Attorney General. And for me personally, I'd be nowhere without Joe Rubin, and I want to thank him again for his extraordinary efforts.
Thank you, Attorney General. That would be next, Mr. Rifkin.
Thank you very much, Your Honor. It's my pleasure to be here. I first want to note for the record that The city of Hartford first sought intervention in this case in 2007. And in doing so, the city asserted at the time, and I think this is significant, that it was the city of Hartford that had an interest and a legal obligation to remedy the racial, ethnic, and economic segregation in the Hartford schools. We believe that what is before you, and others have said that this today, is a blueprint that will meet the promise of Sheff to afford substantially equal educational opportunities to Hartford resident minority students without regard to race or ethnicity in a desegregated setting. In saying that, it's important for me to say on the record and to recognize that the city and the Hartford Public Schools will have an ongoing obligation to afford those Hartford students who do not choose to apply to choice Sheff schools a quality educational opportunity that meets the demands of the 21st century society and that is second to none. I want to echo Martha Stone when she recognized your work, Your Honor. Your hard work, dedication, insight, and guidance you have displayed and given throughout your involvement with this case is significant. You have kept the parties at the table, and as you would often say in chambers to all of us, we all need to keep talking to each other, end quote. And then we'd walk out of chambers and say, well, what did he mean by that? This, Your Honor, is the result. And we thank you for that. Finally, I just want to note about Elizabeth Horton Sheff and Martha Stone, a good friend. They're both the embodiment of the adage that one person can truly make a difference. And I thank them for that. Thank you.
Thank you.
Your Honor, I do believe Elizabeth Sheff would like to say a few words.
Shirley,
Thank you. May I, Your Honor?
please.
Thank you. Okay, so Your Honor, Attorney General Tom, counselors, community, and my family that's online. Milo noted for you already that, Martha noted for you already that today is Milo's birthday. I also place in that same timeline the fact that Milo has a son named Milo, who has a son named Milo. So we have 3 generations of Milo since we started this journey. I woke up this morning thinking, okay, I feel like a mom who is bringing her child to school for the first time on the first day and entrusting a child to the school system that is going to nurture and teach and encourage my child. Sheff is my child, and today I turn Sheff over to the school of the state of Connecticut and trusting that what we have come to develop as a really good working relationship will extend throughout the 10 years and beyond. Because, as I say all the time, our children are our most precious resource, and the most important thing we can do for children is to provide them with an education that prepares them to live in a multicultural, globally economically connected world. So I want to thank all of you all and those people that have been in the trenches, those names that I know and those names that I don't know, And I too want to thank you, Judge Berger, for being there. I'm just so thankful for the support that you have given us, and to all of the counselors here today. And I look forward to seeing you this afternoon, Attorney General. And I just want to say, please take care of my baby. You know, I'm giving you my baby. Please take care of my baby. Thank you, Donna.
Thank you. Mr. Cunningham, is there anything you wish to say? Darren?
No, thank you, Your Honor.
Okay. And Mr. Lohr, is there anything you wish to say?
No, thank you, Your Honor.
And at one point in time, Dennis Parker's face was here. Dennis, where did you go?
I am still here and ecstatic at being here. And the only thing I would say is thank you all, and I look forward to seeing this plan implemented and Connecticut taking a very important step toward equity and equality.
Thank you. Counsel, is there anybody else that wished to talk? Hearing nothing? Okay. I too want to thank a number of you. I want to thank all of those state and local officials. I want to thank the number of governors who have come and gone as this case has been litigated, and especially now our current governor. Because as I recall, there was somewhat of a change when Attorney General Tong and Governor Lamont came into this case. I want to thank them for that. I want to thank all of the commissioners of the State Board of Education. At one point, I believe there were over 10 of them who have been involved in this case. The same thing with the Hartford school superintendents, at least that many. I want to thank our very talented state and local employees who have worked on this case, all of whom have worked to reach today's milestone. Over the last 25 years in this court supervisory role, initially my colleagues, Judges Orajummer and Peck, and then myself, we have been fortunate to work with extraordinarily talented counsel to achieve the many stipulated judgments which have led to today's permanent injunction. And for that cooperation, that dedication, that bipartisanship of our two branches of government, which we are clearly not seeing in other parts of this country, as well as the agreements between the state and its municipalities. Thousands of Hartford students, including others in the Sheff area towns, have benefited and will benefit from a quality education in a reduced isolation and desegregated educational setting. This agreement exemplifies what our system can produce, not just through the hard-fought litigation, which, as Martha indicated, began in 1988, brought by private parties, including one young Milo Sheff, and culminating in the historic Supreme Court decision in 1996. But rather the willingness of our citizenry to cooperate, to compromise, to reach this accord, which benefits all of us. It is exactly what Chief Justice Peters hoped for when she said, "We direct the legislature and the executive branch to put the search for appropriate remedial measures at the top of their respective agendas. We are confident that with energy and goodwill, appropriate remedies can be found and implemented in time to make a difference before another generation of children suffers the consequences of a segregated public school education." Connecticut should be very proud. With that in mind, in accordance with our statutes, I do give my preliminary approval to this permanent injunction. And we await further approval by the legislature to enter this as a permanent injunction, finding that the constitutional violations are being remedied through the comprehensive school choice plan, which is made part of this injunction, and thus ending, with certain exception, this court's supervisory role. It is so ordered. Thank you to all of you. And while this is pending before the legislature and over the next 10 years, I urge you all to keep talking. Thank you. Unless there's something else, we shall stand in recess. Thank you.
Thank you.
Thank you, Your Honor.
Your Honor.
Thank you.
Court stands in recess.
Did we leave down? Okay.